I am a senior attorney at Environmental Defense Fund. I've been with EDF for a little over 3 years now, and prior to that, I was with the Illinois Citizens Utility Board for almost 7 years. So the entirety of my career, I have been practicing before the Illinois Commerce Commission. I started off with more consumer protection focused utility regulation, but as many of you will know, CUB also has a strong clean energy focus. So I've been lucky to get to work on some clean energy and environmental issues throughout. And then when I came to EDF about 3 years ago, I really honed in more on the environmental side. I do specifically focus on clean energy, both electric and shifting to electrification from natural gas use. So I have been doing that for quite some time, and I'm excited to be here sharing with you all. So I'll kick it over to Nikhil for his intro too.
Thanks, Christie. Hey, folks, this is Nikhil Vijaykar. I am a staff attorney with the Environmental Law and Policy Center, also here in Chicago. I come here by way of California, originally from California. It's where I started my career. Did a little bit of practice before the California Public Utilities Commission, and then ever since I've been in Chicago, I have done a little bit of work in the energy efficiency space. Then was practicing before the Illinois Commerce Commission, doing work on behalf of utility clients, so water, electric, gas. And now at the Environmental Law and Policy Center, a lot of my practice is focused on utility regulation and litigation, some of which is at the ICC, as well as before the equivalent agencies in Ohio, in Indiana, Michigan, in Minnesota, some of which are closely parallel to the work that the Illinois Commerce Commission does. And my work at ELPC is specifically focused on electric utility distribution planning, and I'll touch on some of that as we go through the presentation today, but thanks to IEC for having me, and excited to chat with you all.
All right, should I jump into the meat of the presentation?
I think that sounds good.
Okay, great. There are a few materials if you want to follow along a little bit, but first I wanted to give, I know there's a pretty broad range of folks here, some of whom are very familiar with the Illinois Commerce Commission, which I'll refer to as the ICC or the Commission, some who don't know all that much about what the Commission does. So I'm going to start just by showing a little bit, hopefully you can see my screen here, from the ICC website. So the Illinois Commerce Commission is charged, it's a state agency, but it has been given the authority by the legislature to regulate public utilities. And there's a pretty marked delineation of what constitutes a public utility that's regulated by a state agency like the ICC and what's not. So for some really high-level background, the distribution utility is the company that actually delivers energy to the end user, whether it be electricity or natural gas. And that's opposed to a company that's responsible for the interstate sale and transmission of electricity or gas. Those things are federally regulated, as you might expect from it being interstate. That includes interstate pipelines, transmission lines, and it also includes wholesale markets for the commodities. So that differs from the utilities that we have in Illinois. Specifically, that would be ComEd for electricity in Northern Illinois, or Mid-American if you are in one small little Western area. Downstate, it's Ameren for your electricity and some folks for natural gas. And then in Northern Illinois, you have Peoples Gas that serves exclusively the city of Chicago and Nicor that serves the suburbs. And the Illinois Commerce Commission is charged with regulating these public utilities because they have a monopoly service, and it's an essential service. So it's important that the Illinois Commerce Commission makes sure that rates are set appropriately and that the utilities are providing safe, reliable, and affordable services to their customers. The Illinois Commerce Commission is led by these 5 commissioners you see here, a chairman and 5 commissioners. They are appointed by the governor and they each serve a 5-year term. They are staggered, so you don't lose all your commissioners at once. Then there's a significant number of administrative law judges, and they actually run sort of the day-to-day practice of what happens at the ICC. And the administrative law judges, they run individual dockets, and then it's their job to make a recommendation to the commissioners as a whole as to what decisions they should be making on cases. They write a proposed order and a memo to the commission, and then the commissioners have regular open meetings, special open meetings, and bench sessions where they ultimately make decisions and they issue the final orders. And if you're ever interested in seeing what's happening at these regular open meetings, there's 2 ways to do that. During normal circumstances, they are all open to the public, so you can go live and join. You can see up here, they have the schedule of the next special and regular open meetings that are listed. And if you click on any of them, then it'll take you to where you can actually listen live when the meetings are happening. And ahead of time, you can always get on and you can see what's going to be on the agenda. You'll also see here that the Commerce Commission is also responsible for certain transportation. That includes railroads and motor carriers, such as moving companies. So they have a pretty broad jurisdiction. They have to have a lot of different expertise. Here's an example of what one of their agendas looks like for a special open meeting that's going to happen tomorrow. But for our purposes, we're going to be talking about the public utility regulation side of what the ICC does. The ICC functions largely under the Public Utilities Act. For those of you interested in looking it up, that's 220 ILCS 5. Most of what they do falls under that, although there's a few things under a few different sections. Most of what we're going to be talking about is the Public Utilities Act. And the rules of practice before the Illinois Commerce Commission are, oh dear, now I can't see it. Well, technology foiled me on that one, but there's a link on the materials to the rules of the Illinois Commerce Commission, which has everything that Nikhil's going to talk about for how you intervene, how that cases, which are called dockets, actually run. And also, if you're ever interested in looking up any of the dockets I meant to show on the ICC website, it's really easy to do that. And we have one of the better systems. Every state has a Public Utilities Commission. Some places call it a Public Services Commission. And then some have jurisdiction names, like we call ours the ICC, but ours is one of the better systems for being able to actually see what's been happening in a case, look at all the documents that have been filed so far, all the different parties that are participating in a case. So we're very fortunate to have a great e-filing system, especially right now. And with that, I think I will turn it over to Nikhil, and he's going to give us some sort of concrete examples for the kind of work that we regularly do at the ICC.
Yeah, thanks, Christie. That was a helpful setup. And you know, I'm gonna get into one type of case that you hear a lot about when you think about a utility regulatory commission, which is a rate case. I think for those of you who work on rate cases, or even for those of you who have just heard of it, rate cases can be this sort of obscure, maybe a little bit opaque area of utility law and procedure. But I think what's important to remember is something that Christie just mentioned, which is that, you know, utility regulatory agencies like the ICC cover a really broad range of cases. broad range of issues, some of which I tend to think about as the all kind of focusing on the terms on which people have access to some of these really fundamental resources like water, gas, light. Um, Clearly, there's significant environmental implications to some of those decisions. There's also huge fairness and equity implications to some of those cases and decisions, which is a big part of why I got into this work. Um, and so some of those cases that kind of fall under the purview of the ICC include, simple things like complaint cases for things like disconnections or rates. And then kind of at the other end of complexity on the spectrum is a rate case. So I'm going to use a rate case as kind of an example of the procedure before the commission and what a case looks like. A lot of what procedure looks like and what controlling law looks like before the ICC is similar in other states. A lot of the principles are similar, but of course the details differ, and every utility commission is a little different as far as the procedure that it follows. So one of the areas of the ICC's authority is to set rates. When a utility would like to raise its rates, it has to petition to the ICC under Section 9201 of the Illinois Public Utilities Act. The ensuing case that kind of comes out of that petition looks a little different in Illinois if you're an electric utility or if you're a gas utility, gas and other utilities. Electric utilities are under what we call formula rates, which a lot of you might have heard of. What that means, to put simply, is that some components of a traditional rate case in the electric utility context in Illinois are fixed and based on formulas. So it kind of limits the set of issues that are contested in a electric utility rate case, whereas on the gas or on the water side, the rate case tends to include several more components, tends to be a little bit broader, tends to have several contested issues contested by a lot of different groups. I'm going to use just a sample rate case that was actually decided and litigated here in Illinois, just to frame our discussion. It is the Nicor gas rate case, docket 170124, that was filed in 2017 and then kind of got litigated over the course of the next couple of years. So here, the applicant utility was an Illinois gas utility. Nicor serves areas in Illinois, kind of in the northern half of the state, Chicago suburbs and beyond. And so here in this case, the utility filed their case in March of 2017. They were looking to increase rates, which generally means that they were looking for a new revenue requirement, so increase in their expenses, investment, and returns to be collected from ratepayers. And they were looking for approval of a new rate design from the ICC. A rate design basically means how are they going to structure their rates to recover that revenue. So in a case like this, the standard that the utility has to meet is the just and reasonable standard, again, that's provided under Section 9201 of the Public Utilities Act. They have to show that their proposed rates and then the proposed components of those rates are just and reasonable by that standard. And the burden of proof in a case like that, which is true for a lot of cases before the Public Utility Commission, is on the applicant utility. So it was on Nicor. They had to show that their proposal was just and reasonable. I'm going to pick on one proposal from that rate case just because I found it and I think it's relevant to a lot of the folks on the call. There is a proposal in that case specifically to increase their customer charge from $14 to $18. It's a part of everyone's gas bills. It's a fixed customer charge, and the utility was proposing to increase that. A lot of groups got involved in this case. For the purposes of our discussion, I'm going to make up a group, a potential environmental intervener that was not involved in this case and is completely fictitious, but could have been. And I'm going to call it the Illinois Citizens for Energy Efficiency Harnessing Our Therms, which conveniently is acronymizes to Icy Hot. So Icy Hot is an organization with paying members all over Illinois. Their interests are in promoting energy efficiency and conservation. And let's just say some of whom live in Nicor service territory, so they receive gas service from Nicor. So, we only have a short amount of time, so I can't go through all the different components of a case. But if you look at your handout, I kind of mapped out some of the basic elements, and I'm going to focus actually just on 3 areas within that basic structure that I think will be of particular interest to this group. From the standpoint of, your typical intervening group who's interested in a case like that. And so those 3 parts are: first, participating in a case; second, building your case; and then third, kind of arguing your case, right? So let me start off with participating in a case, because I think this one deserves a little bit of attention. So taking a step back, participating in cases before the utility regulator, before the ICC, is not, I wouldn't say it's the easiest process, and I think folks there are some challenges associated with it. There's a couple different options. Typically, members of the public can address the commission at its meetings, as Christie mentioned, which are open to the public. You can submit public comment on any open case, either by submitting written comments or by calling the ICC. And then there's a more direct participation in a case by way of intervention. So intervention in a contested case before the ICC has specific requirements associated with it. Those requirements are set by statute and by the Commission's rules. Section 200.200 of the Commission's rules say that any interested intervening party that is petitioning to be part of the case must set a plain and concise statement of the nature of your interest. I'm not going to go too far into kind of what that pleading requirement translates to, but I just wanted to mention a couple of things that I think might be of interest to you folks. Intervention in Illinois, based on the Illinois Code of Civil Procedure, kind of breaks down in 2 ways. There's intervention as a right, is when intervention is statutorily permitted. And then there's permissive intervention at the ICC's discretion upon a showing of sufficient interest, basically saying, you group who is interested in participating in this case, do you have a sufficient interest by law to be an intervener in this case? A note on what that sufficient interest might mean, and for the attorneys in the crowd, it's a case that you folks would be interested in is Egyptian Electric Co-op Association versus the Illinois Commerce Commission. This is 33 Illinois 2nd 339. It's a 1965 case, but it's still cited often. And it represents, its holding is relevant to illustrate what a sufficient interest in a case might mean. In that case, just for a little bit of background, the ICC had entered an order authorizing the Illinois Power Company to construct an extension of a power line. The commission approved this, the circuit court affirmed, and a co-op association that was interested in intervening and was denied intervention appealed this to the Supreme Court. Now, this co-op association tried hard to show it had sufficient interest, first as a competitor, then as a consumer of energy, as a landowner, but the commission wasn't having it, nor was the court. Essentially, the court held that there was no showing that the rates would be affected, and there was no showing that the intervener group that the proceeding would have a direct and adverse effect on the rights of the intervener. So that's kind of the standard that you want to keep in mind. I think from the standpoint of, the NICOR rate case, just to put this into context of how this actually played out. In the NICOR rate case, the Illinois Propane Gas Association petitioned to intervene in this case, which is a nonprofit trade association, including independent corporations involved in the supply of propane gas to customers in Illinois. This is a competitor of NICOR. So NICOR challenged, saying that the Propane Gas Association had no interest, not a sufficient interest by law to be allowed to be an intervener. Illinois Propane Gas Association pointed out that first of all, it was an incorporated association, and then it said we need to intervene because we have an interest in making sure that NICOR competes on a level playing field. And the commission found that that was a sufficiently direct and adverse effect on their interests in order to allow IPGA to intervene in this group. So, what do all these intervention standards boil down to in the case of our fictitious intervener, Icy Hot? Uh, I think what it means is that you want to make sure that you articulate your interests in the case when you're petitioning to intervene. Um, Oftentimes for organizations, and we don't have time to get too deep into the question of organizational standing, what it means for your membership to have standing versus the organization itself to have standing. But I will say that, for the ICC, with the ICC standards, it's important to articulate the direct and adverse effect that a proceeding will have on the organization's interests, so on Icy Hot's interests. Um, and it is helpful to articulate how the members themselves might be affected. What I would caution against is articulating just the membership's interest without articulating why Icy Hot itself has an interest in the proceeding. So that's intervention and participating in the case. I'm going to skip ahead to building a case. Again, here, procedures and norms vary by state. And I think one of the big things that groups that are getting involved in proceedings before the ICC find is that, there's this asymmetry of information. The utility that's initiating a rate case has a lot of information. It provides some of that information as a part of its filing for a rate increase. But, groups that are getting involved rely on discovery tools in order to gain more information about the utility's proposals and figure out, if and how they can challenge those proposals. So in Illinois, data requests are common as a discovery tool. In fact, those are encouraged as opposed to formal discovery tools like depositions and subpoenas. And it is, the rules prescribe that there is a 28-day turnaround for responses to data requests. It is common for parties to agree to a faster turnaround on those discovery requests. And that kind of helps when you have a proceeding that's a little bit condensed in order to, promote more efficient exchange of information. So discovery is your opportunity to learn more about the case the utility has filed, and then inform the development of your case, which is generally through testimony. So, on the subject of testimony in the NICOR rate case, for example, several parties that got involved submitted a couple rounds of testimony then over the summer of 2017. Those parties included groups like the AG, CUB, which is where Christie used to be, other groups like the Illinois Propane Gas Association that was eventually granted intervention in that case. One note on testimony, in this case, in the NICOR rate case, no parties filed motions to strike testimony, although the AG did eventually end up filing a motion to strike a portion of NICOR's reply briefs for making statements that were not supported by the record. But I bring this up because this is something that you see sometimes at the case development stage, motions to strike. I think why that's relevant to a group like Icy Hot is that you want to make sure that as you're developing your case, and in the case of Icy Hot, which is coming into this case to challenge the utility's customer charge, you want to make sure that your witnesses are qualified to present the evidence that they are presenting, and that they are, their evidence is staying relevant to the proceeding itself. It's not straying off into, issues that are not relevant to the request that the utility is making. And moving past kind of the building a case stage, which develops through rounds of testimony, I'm going to get to the arguing a case stage. I'm going to start that off with the hearing process, which the hearings are really more a part of your building a case stage than the arguing a case stage. But I want to touch on it just because it is a little bit different in different states, and it's an interesting part of the ICC process. Typically, a hearing involves one or two administrative law judges. If it is a quote unquote paper hearing, which does not involve live cross-examination of witnesses, but rather entry of evidence through affidavits, then the proceeding generally proceeds over the phone. If it is a live hearing, it's an opportunity to test other witnesses' evidence in person. Some things to consider are in some states, this doesn't really happen in Illinois, but in some states you might have commissioners attending the hearing, and you might consider their understanding of the case as you're going through your preparation for hearing. In some cases, you might want to consider the administrative law judge that's hearing the case. Some ALJs tend to ask more questions or less questions to keep things moving. So the hearing process ends up being a place to kind of test the other parties, your last opportunity to test the other parties' cases before their testimony gets entered into evidence, and you kind of move forward into the briefing phase of the proceeding. The briefing phase of the proceeding has several different components. There's the actual initial and reply briefs. Once the administrative law judge enters a proposed order, there's an opportunity to enter, generally an opportunity to enter exceptions to that proposed order. And then once there is an order from the commission, if you are still not satisfied with that order and where it landed on your issues, there generally is an opportunity to petition the ICC for rehearing and or then appeal the case, which Christie will touch a little more on appeals. Just wanted to tie this back again to our NICOR rate case. For this case, there were 2 days of cross-examination that happened in September 2017, and then briefing that followed in the fall. Our customer charge issue that I brought up, the AG actually briefed this issue. The commission issued a proposed order, the ALJ issued a proposed order in December 2017, and then that was shortly followed by an order in January 2018. And then this case actually ended up proceeding to appeals. So this whole briefing phase of the case, what does all this mean for an organization like Icy Hot? You've come in, they filed testimony, maybe relevant to this customer charge issue. At hearing, maybe they choose to cross-examine the company's witness on rate design, or maybe they choose to cross-examine the company's witness on the cost of service, so the cost of serving customers. They may, in turn, find that they are asked to defend their witness if the utility wants to test Icy Hot's expert witness. Once you make it past the hearing stage, hopefully Icy Hot's testimony survived any motions to strike, you move on and they would brief the case. And then you get to the point where you get a commission order, and let's assume for this scenario that it's an unfavorable order. The commission didn't adopt their recommendations on the customer charge issue. So then the question becomes, where do we go from there? How do we make the decision on whether to appeal this or not? What are the chances of success? And that's where you start considering some of the standards of review for a commission's order and whatnot. So I'm going to leave it there on process and pitch it back to Christie on appeals.
Thanks. So because I think that ICC appeals are a little bit interesting, they're unique from the way that an ICC process happens, and there's far fewer practitioners that get involved in appeals and have the experience. I want to address both the process of appeals and then sort of the substantive standards that are at play as well. There's typically, when an appeal is filed, some organizations and some state agencies, for example, the Illinois Attorney General's Office and the Illinois Commerce Commission staff themselves actually have a separate appellate bureau. But nonprofit organizations like us, often it's the same practitioners who were working on the case that also work on the appeals. So hopefully this is helpful in the event that you ever need to get involved in that. So as Nikhil mentioned, there's a final order. That's when the commissioners actually vote from the bench on what they are ordering in the case. After the vote is taken, then the final order is actually published, and that sets off a clock with some pretty stringent timelines. And I want to go through those pretty quickly because they're not all in the same place. There's not really any one spot where you can find all the information. You have to look at a few different things. One is the Public Utilities Act that we talked about earlier. Another is the ICC's Rules of Practice. Then you have the Illinois Supreme Court Rules of Practice. And then finally, you have the local rules of practice for the Illinois Appellate District where you're filing your appeal. And I say filing, but you might also be a respondent to the appeal as well. So after the final order is actually issued, not the day of the vote, but once it's sent out by the clerk, that starts a clock for filing a petition for rehearing. That's still at the Commerce Commission level. Parties can ask for rehearing. They have to do it within 30 days of it being filed. And only after a petition for rehearing is denied can you file your appeal. After an application for rehearing is filed, the commission has 20 days to rule on it. And the application for rehearing needs to state with specificity the issues on which you're asking for rehearing. The records in these cases are frequently hundreds of pages long, and it's required that you narrow down what you're asking for rehearing on specifically. And if rehearing is granted, the scope of the rehearing will be limited to that issue that you asked for rehearing on, or those couple of issues. And if you are asserting any new facts, you have to state those with specificity in your application for a hearing as well, and you have to file a verification, which means that you have to file an affidavit that you get notarized for that. Assuming that your application for rehearing is denied, then you are allowed to file a notice of appeal and a petition for review to the Illinois Appellate Court. And the district that you should file that to depends on where the utility is cited that you are appealing the order from. So for example, if it was People's Gas, they're cited within the first appellate district, you would always go there. NICOR has territory in both the first and second districts. The first party that files a notice of appeal basically gets their choice of which appellate district to file in, if it's a utility that spans multiple jurisdictions. So there have been times when folks think that one district or another is going to be more advantageous. So there's an advantage if you think multiple parties are going to be filing an appeal to be the first one to file so that you get your choice of district. After you file your notice of appeal and petition for review, which again are laid out in the various statutes and rules that I cited earlier, and they're also all included on one of the handouts that I saw was linked a little bit ago in the chat box. Like I said, you go straight to the appellate court. You don't have to go through the circuit court first. So then it's on sort of a couple of different tracks. You have 14 days after the time you do that to file your docketing statement. Concurrently, the Illinois Commerce Commission is preparing the record in the case. That consists of all of the evidence that was admitted, all of the written testimony, all of the briefs, any data requests and cross-examination that was admitted during the hearing. And usually that takes a pretty significant amount of time. Under the rules, they're supposed to do it within 35 days. They almost always need an extension, understandably, to get these hundreds of pages of the record prepared. But that's important because you have to know the day that they file that record, because that sets off then the timeline for when opening briefs are due. So as the appellant, you must file your opening brief within 35 days of the Illinois Commerce Commission filing the record. And when you become involved in the appeal, you'll get on the service list so you'll know, and they'll reach out ahead of time if they are asking for a delay, so you know. And then that sets off the different triggers for filing the opening brief. The appellees then file their responsive brief, and then finally 14 days after that, the appellant gets to file a reply brief. And again, there's ways to ask for extensions of any of these, and frequently, because this is incredibly complex litigation, that does happen. So these appeals, it's not unusual to have an appeal last well longer than a year after an actual final order of the Illinois Commerce Commission. And one of the reasons that's particularly relevant is because there are no refunds allowed from an ICC order that's considered retroactive rate making. So for example, if rates are set at a level that turns out based on the appeal to be too high, the period of refund is limited to it's usually not possible. If in your request for appeal, you ask specifically that the amounts be subject to refund, there can be a trigger from the time the appellate court makes their decision until the utility amends their tariffs to set new rates into practice. That can be considered a period of refund. But for the most part, any amounts collected during the pendency of the appeal are not refundable. And time is just flying by, so I'll really quickly just say, pay really close attention to the local rules in particular for things like there's specific requirements for what color the cover page of your brief has to be, depending on which round of briefing you're in. There are really strict page numbers, and the appellate court does not like it for you to go over those. They have specific requirements about how you lay out your table of contents. There's even going all the way back to the docketing statement that I mentioned earlier that you have to file within 14 days of your notice of appeal and petition for review. There's a very strict form that you have to follow for that. So it is a really specialized area of law, even with the very specialized area of law of utility regulation that the ICC is managing. And it's also important to know, by the time you get to the appeal, there is no new evidence taken. Any appeal is based strictly on the record from the case below. There's no new discovery, there is no new testimony. And that's really important for a couple of reasons. One is that the standard of review in appeals is incredibly high. Any decisions by the ICC are considered to be prima facie reasonable, and the burden of proof is on the appellant to show otherwise. There's a few seminal cases that I laid out in the handout that you have that I encourage you, if you're interested, to look into a little bit more. But a few highlights of the standards that are at play here are that Commission's findings of fact, as I said, are considered prima facie reasonable. Now, that's different than statutory interpretation, which is reviewed de novo. And both within the PUA and then later interpretations within case law is maybe one of the most important things here in appellate practice, which is that review of ICC factual findings, because they are considered prima facie reasonable, are limited to three things. One is whether the Commission acted within its authority. Two is whether the Commission made adequate findings to support its position. Three is whether the decision is supported by substantial evidence, and there is some case law there to help interpret what substantial evidence means, but it's typically evidence that a reasonable mind would accept as sufficient to support the challenged finding, more than a scintilla, but less than a preponderance of the evidence. And then finally, whether any constitutional rights have been violated. So as you can hear there, that's a pretty high threshold for overturning any factual findings of the Commission. It does happen on occasion, but you have to be very mindful, and it's helpful even in your application for rehearing if you know that you're going to be interested in filing an appeal if you don't win on a particular issue, to have those standards in mind throughout so that you are writing your briefs and preparing to make those one of those four arguments, because as I said, your entire record in the ICC case is all that you can cite in your appeal, aside obviously from relevant applicable law. So if you think that you're going to be appealing, really have at least one of those four in mind and start making your case for that as early in the ICC proceeding as you can, but no later than the application for rehearing. Another important standard is there is no res judicata, technically speaking, in ICC proceedings. So the Commission is free to deal with similar or even identical matters differently in each case. The appellate court has discussed the extreme complexity of the issues that the ICC handles, and that the underlying facts can make for justification of a different decision. However, and you'll see this in any ICC appeal, one side is going to argue, well, recall, there is no res judicata in ICC cases. And the other side that's making the counter argument is going to say, yes, however, commission decisions are entitled to less deference when the commission drastically departs from past practice. And that comes from one of the business and professional people for the public interest cases. If you do any ICC appellate work, you're going to hear all about the BPI cases. There's BPI 1, BPI 2, and BPI 3. That particular one is from BPI 1, which is in 1989. But you'll see both of those sides getting argued. One, there is no res judicata, yes, but where it significantly departs from past practice. So those phrases come up an awful lot. All right, charging right through, we're at 12:46 already, and I do want to make sure we leave some time for questions. So maybe I'll just give a couple more quick statements and then let Nikhil give any conclusions so we have time for questions. How can you get involved in ICC cases? You can intervene, as Nikhil mentioned. You can file public comments online if you look up the docket number of the case that you're interested in. You can give live public comments, as Nikhil mentioned, or you can get involved with an organization that's intervening in a case, and you can stay up to date that way. Do not violate ex parte rules. That means that once a case is filed, you may not get in contact with a commissioner, an ICC staff member, an administrative law judge, and try to give them information about the case. That's considered a violation of ex parte rules. So any statements that you want to give to anyone at the ICC once a case has been docketed has to be done through one of those public forums. And then why does all of this matter? ICC, obviously, by regulating public utilities, has an incredible influence over environmental issues, and that comes up in a number of ways. For one thing, the way that rates are designed matters from an environmental perspective. The more of your energy usage that is in a fixed charge versus a volumetric charge, that makes a difference as to how incentivized you as a consumer are to reduce your usage, which we know obviously has incredible environmental impacts, particularly if you do so at peak times. And the ICC has the ability to attempt, to the best of their ability within legislation, to align utility plans and spending with the utilities, with the state's goals. So I'm sure that you've all heard plenty about the Clean Energy Jobs Act. That's one of the main goals of that. And then Nikhil, I'll toss it back to you to finish off. Why does the ICC matter to environmentalists?
Yeah, thanks, Christie. I mean, the way I think about it, if you consider the fact that, power sector and transportation sector collectively make up roughly 50% of GHG emissions today, a little bit higher, and you think that kind of tells you then that the decision points around how electricity is generated and used and how buildings are heated and cooled and how people get around, I mean, that's a significant wedge of the climate puzzle. And then you kind of think logically the next step, which is that the ICC's jurisdiction over public utility activity, even in a state like Illinois, where it doesn't have direct jurisdiction over generation, it affects utility decision-making at kind of each one of those outcomes. Christie mentioned the rate-making function, which affects energy efficiency and conservation, which is a huge part of it. And now as we move forward, I think as a function of what's in some of our laws, like FEJA, like potentially the Clean Energy Jobs Act, the ICC regulates so much of what's going on the distribution grid for electric utilities, distribution grid for gas utilities. That means that as you think about the implementation of distributed energy resources, so going beyond energy efficiency, we're thinking about solar and battery storage, a lot of what's going on the distribution grid, how that's compensated, how that's integrated, how that's allowed to play. all of that falls under the ICC's jurisdiction. And then, of course, the rate making function affects usage and conservation. And some of the infrastructure that's going to affect electric vehicle deployment falls under the ICC's jurisdiction. So lots of nexus with kind of big wedges of climate action that we all know about. So I'll stop there. I think, what do you think, Christie? It's question time.
Yeah, let's do it.
Great. Well, thank you both for that, for both your presentations. That was really thorough, and I know I learned a lot. So we'll take the questions as they come in. So we have some stacked up already, and the first came to me privately, so it's not in the chat for everyone to see, but I'll read it off here. You mentioned that water is a public utility that is essential to citizens. Is it regulated similarly, and who governs access and quality on that side?
I can take a quick crack at that, since I think I was referring to what I said. So yes, water is a regulated public utility in the state of Illinois. There's some sharing of responsibility between the IEPA and the Illinois Commerce Commission. The Commerce Commission's jurisdiction is to set rates and to make sure that water is delivered safely and reliably to people, but typically water quality standards are regulated by the IEPA. So hopefully that kind of covers the question. If there was a subpart there that I missed.
I think that does cover it well. And another question here that came to me privately. So apologies. Maybe I can try and copy and paste these into the chat so everyone can see them. But when CUB or other groups appeal to consumers to support them in fights against utility rate increases, usually it's said that the increase is not justified. So what investigations are done, and what in their view makes rates unjustified? And then there's a second part there that asks, what does the utility do to counter these challenges?
Well, when you hear an organization like CUB talking about the fact that rates aren't justified, it typically means that the utility has requested a rate increase, and for various reasons, the expert that the organization is using have found reasons that rate increase is not justified. Maybe it's because they are using an accounting methodology that makes it look like rates need to be higher than they actually do. That's a really technical but not altogether uncommon issue, which is why it's important that that nonprofits have to have the expertise of their own accountants and engineers in order to effectively litigate these cases. It might also mean that the utility is doing what we sort of refer to colloquially as gold plating their system. So utilities have an incentive to spend as much on infrastructure or capital spend as possible, because not only do they get to recover the whole amount that they invested, but they also get to earn a profit on that, because as a monopoly utility, their level of profit or their rate of return is based on what the Illinois Commerce Commission sets as, say they were in a competitive market, their profit level would probably be at X. Right now, a lot of them are around the 10% mark. It kind of ranges between like low 7 to close to 13, depending on the jurisdiction that you're in. But it can also mean that the level of profit that they're asking for is unjustified. You know, if the economy is tanking, then they shouldn't be getting a 13% return on their investment. It should be a lot lower. Nobody else is getting a 13% return, and we sure would like to. So that's just a few examples. And the utilities have a lot of experts. They have both a lot of experts from the utility themselves, but they also pay big dollars to outside consultants to come in. There's times when I've seen them have 15 different witnesses in a case, as opposed to our 2 or 3. So it really is a little bit of a David and Goliath fight, but we are small but mighty.
Thanks, Christie. All right, I will bump down a bit to another question here. So the first question here looks to be for Nikhil. So what statute section covered just and reasonable rates?
That was section 9201 of the Public Utilities Act is where that standard comes from, specifically subsection C. And I'll say that section is, sorry, I was just going to say that section it covers more than just the standard. It kind of explains what the utility would submit as a part of a request for a rate increase, but it also includes that just and reasonable standard.
Great. And then the second part of this question asks, what percentage of ICC's public hearings are canceled if nobody provides notice that they would like to speak over 24 hours beforehand?
Well,
they aren't canceled. Special open meetings and bench sessions go forward, and the commissioners have to give a live vote on any issues that were on the agenda. It has become, unfortunately, far less common to have public comments. In part, that's because there was a period of time when they just weren't getting as much attention from the commissioners. In my personal opinion, I think that they matter more now to the bench that we have, and I do encourage folks to get involved because I think that the commissioners that we have are interested in hearing from the public.
Great. And then we have about 3 minutes left here, so, and about 3 questions. So maybe we can quickly cover these. So how often do commissioners recuse themselves for reasons of prior involvement with the party in the case? And then I think this is related. How strictly is section 2108 enforced?
do you know of recusals, Christie? I don't know how common that is, or have not heard of it personally.
I've seen 1 or 2 in 10 years. Very uncommon.
Can I add a little to that question, possibly?
We have 2 more questions, so if we can do it quickly, then yes.
Recently, Governor Pritzker appointed Michael Kerrigan, who was the previous head of the AFL-CIO, to be a commissioner. And the indications that we have is that he will never vote against the party if there is a union supporting that party. And it's in many of our situations involve some sort of construction. There will almost always be a union coming in support of the construction, regardless of how bad it is. And it seems very wrong to have a person who will not vote against a union position, which is the same thing as a utility position in most cases, in there giving a vote. We're trying to get him, we're wondering about how we can get him to recuse himself. By the law I cited, he ought to do it, but we understand he's got no interest in doing it. He thinks he can get away with it.
Because commissioners are political appointees, it does come up that parties would like to see them recuse themselves based on their prior positions. You know, there's a process for suggesting that should happen. I don't think that commissioners are likely to take kindly to it. Unfortunately, that, you know, they're just people and they don't want to hear that you don't think they can make a fair decision. So like I said, it's a pretty uncommon thing, in part just strategically. Times when I've heard it talked about in the past, it's been decided against asking for that reason.
Great, thanks. And then I'd love to end with this question because I think this group would like to hear it, but to what degree has the ICC considered the impacts on climate change in their decision-making up till now? And then I might ask Gavin if you could throw some of those links in the chat while we wrap up here, that'd be great.
I can take a crack at it first, and then I'm sure Christie, you'll have plenty to add. So in general, the ICC's mandate does not include considering climate change impacts specifically in their decision making. Having said that, there are a lot of ways in which climate change impacts, at least indirectly, come up through their decision making. For example, if there's legislation, let's just take FIJA as an example of legislation that amended the Public Utilities Act and therefore requires the commission to take specific actions that have direct climate change impacts. Well, then to the extent that the Public Utilities Act, directs the commission to take that into account, it certainly is taking into account, climate change impacts, if not directly.
Yeah, I think this question highlights the importance of legislation because it's not a part of the ICC's mission through the Public Utilities Act, or it wasn't until various things were inserted through FIJA, and then significantly more would be added if FIJA is passed as well.
Great. Okay, well, we're at time, a little bit over. I just want to thank you both, Christie and Nikhil, for this really dense with information. We appreciate it a lot at IC, and thank you to everyone who joined. In the chat box there for attorneys, remember to go to islandviro.org/CLE and fill out that form so we can issue your CLE credit. We've recorded this session. It'll be up on IEC's YouTube as well as our website, and we'll do our best to fill in kind of the description of the video with all the links that were discussed today, and link out to both the Environmental Defense Fund, where Christie is from, and the Environmental Law and Policy Center, where Nikhil is from, so you can learn more about those organizations. And with that, I just want to wrap up and say thank you again. If you'd like to become a member of IEC, you can do that on our website. And tomorrow we will be discussing water rates and affordability, which came up a little bit today. So be sure to join tomorrow if you want to learn more about that. And yes, thank you. Thank you again to everyone. And I'll go ahead and wrap up the meeting now. Thank you.
Thanks all.